that Mr. Leon shot April Diaz 11 times.
Tried to set Frank Olton on fire, where he then shot her to death.
He tied up Mr. Olton in the basement. He stabbed him.
When you went to stab the little girl that you treated like your daughter, did you feel the knife go across?
In November 2023, a confrontation outside a Huron home ended with the death of April Diaz, the mother of Andrew Leon's then-girlfriend. Deputies quickly identified Andrew Leon, who was 19 at the time, as the suspect and arrested him shortly after the shooting. The case moved forward, but when it first went to trial in mid-2025, jurors were unable to reach a unanimous decision, resulting in a hung jury and a scheduled retrial. The second trial began in October 2025 at the Fresno County Courthouse.
You'll learn throughout the course of this trial that Mr. Leon shot April Diaz 11 times. It's about what the forensic evidence shows and what the evidence that was located shows in this case. And it shows that Mr. Leon committed first-degree murder in this case.
Prosecutors told the jury that Leon shots after being denied entry into the home, while the defense claimed he acted out of fear during a heated confrontation.
She swings on him once, grabs his arm, and swings again. Now, Andrew, at this point, he looks down. He doesn't understand what just hit him. He looks down, and instead of April's fist, he sees the cold steel of a knife. And shock and terror and anxiety flood his mind as he realizes what is happening.
Diaz's daughter also delivered emotional testimony about the events leading up to the shooting, and responding officers described what they encountered when they arrived. After hearing all the evidence, the new jury found Andrew Leon guilty of first-degree murder. The case now moves into the penalty phase, where jurors will decide whether he will serve life in prison or receive a harsher sentence under California law. In early September, the quiet community of Bellerose in Queens was shaken when a fire was reported at the home of Frank and Maureen Olton, a well-known elderly couple in the neighborhood. When emergency crews arrived, they discovered evidence suggesting the fire had been intentionally set, and investigators soon realized the couple had been harmed before the flames began. Surveillance video from that morning helped piece together the timeline. It showed Jamal McGriff, who was on parole at the time, approaching homes in the area and eventually speaking with Frank Olton at the back gate of the property. Not long after, he was seen entering the house and later leaving with several bags. When family members received an alert from the home's alarm system, they contacted authorities, which led to the discovery of the and the couple's deaths.
It's clear that he went to one door first, and then that person shut the door on him. During that time period, he tied up Mr. Olton in the basement. He stabbed him. He tried to get money transferred into his own account. That was denied by the bank.
Over the next 3 days, detectives tracked McGriff across New York City after noticing the victim's phones and credit cards had been used in Manhattan and the Bronx. He was arrested in Times Square and later charged in a sweeping 50-count indictment, including murder, kidnapping, robbery, and arson.
How do you plead? For Mr. McGriff, pleads not guilty to all the charges.
In court, McGriff entered a not guilty plea, though prosecutors say the evidence linking him to the crime is extensive.
A body-worn camera statement made by the defendant. I'll admit it. I burnt those. Don't matter to me though. I admit to doing it. Tried to set Frank Olton on fire to conceal evidence of this vicious crime, but that fire failed to catch. He appears to have then tied Maureen Olton to a chair upstairs in the living room, where he then shot her to death.
The case has drawn significant attention due to the victim's age, the nature of the break-in, and McGriff's recent parole status. He is scheduled to return to court in November as the legal proceedings continue. In December 2024, deputies in Washington County, Oregon were called to a home on S.W. Edie Road after 64-year-old Mary McDowell was found unresponsive outside her house. Her partner, 38-year-old Jose Lucas Morfin Jr., was present when deputies arrived and was taken into custody as investigators examined the scene. Over the next several days, detectives collected evidence and interviewed witnesses to determine what had happened. Morfin later appeared in court where he denied involvement and entered a not guilty plea.
Please don't listen to the propaganda, Lori. I was there with Mary, and I tried to revive her. I love Mary. They're not my heart.
After reviewing the case, a grand jury issued an indictment on December 20th, charging Morfin with first-degree manslaughter, second-degree assault, abuse of a corpse, unlawful use of a weapon, and being a felon in possession of a firearm.
As investigators were working through the scene, I think circumstances that came out led to him being a participant in her death. That age gap in itself is a concern for our investigators, and the circumstances of her death. We want you to come forward if you know anything about that. As this investigation unfolds and more of the pieces are put in place, those charges could change.
Authorities have not released the exact cause of death, but they say the circumstances point toward Morfin's involvement. He remains in custody as the legal process continues, and investigators are asking anyone with information about the couple's relationship or the moments leading up to Mary's death to come forward. In October 2017, Edgar Vasquez was spending the afternoon at a friend's home just outside Kelso in Cowlitz County, Washington. The boys were running around the house and playing, while the relative was nearby and could hear them moving from room to room. According to investigators, the friend went into the master bedroom, picked up a weapon that was stored there, and racked it. When a single round was ejected, he assumed the weapon was empty. Believing it was safe, he pointed it toward Edgar and pulled the trigger, not knowing the weapon was still loaded. Edgar was stuck and did not survive. Deputies launched an investigation immediately. Because the was only 13 years old, his name was withheld under Washington's juvenile privacy laws. He was arrested the next day and initially charged with first-degree manslaughter. During his first court appearance in Longview, prosecutors called the case unusual because of the ages involved.
The crime that we're dealing with here, obviously, is we have real concerns for access to firearms. We think that the seriousness of the case and the risk of flight and danger call for a secure bond.
The defense called for no bond, citing the defendant's and his family's cooperation throughout.
The client has no criminal history. There's no indication that he is going to be a threat to the community.
The judge set bail at $30,000, ordering that the boy could not leave the county without permission. Over the following months, prosecutors reviewed the full police reports, witness statements, and forensic findings. Ultimately, a judge determined that the evidence supported second-degree manslaughter, ruling that the act was not intentional, but was the result of criminal negligence. In April 2018, the juvenile was found guilty, and in May 2018, he was sentenced to 5 months in juvenile detention, followed by 12 months of probation and 60 hours of community service. In April 2024, deputies in Hillsborough County were called to a home in Dover, Florida, where they discovered the deaths of Amalia Choctepec and her daughter Estrella. The investigation quickly led to Angel Gabriel Kuzchak, who had been living with them and was found hiding nearby in a wooded area shortly afterward. Detectives pieced together the timeline of events and took him into custody the same day. According to court documents, Kuzchak had only recently arrived in the United States from Guatemala, and the case immediately drew widespread attention due to the circumstances and the victims' ages. Over the next year, prosecutors prepared a capital murder case, arguing that the actions were deliberate and met the standard for first-degree murder. During the 2025 trial, Kuzchak testified through a translator, claiming he remembered little about what happened.
I don't remember any of that. Before God, I can tell you, and before all of the people here, I don't remember any of that.
The prosecution challenged his account using evidence and witness statements.
When you went to stab Estrella, the little girl that you treated like your daughter, did you feel the knife go across all 4 of her fingers as she reached up and grabbed the blade?
Even if you were to find that he and Amalia got into some sort of an argument, and during that argument he got mad and that's when this attack occurs, that is not first-degree premeditated murder. That's actually second-degree murder, which you have an instruction of a lesser charge for.
After reviewing the case, the jury found him guilty on all charges. With the verdict returned, the trial moved into the penalty phase, where jurors will determine whether he will serve life in prison or face the death penalty, which the state is actively seeking. In early September, Raleigh police officer Tremail Cogdill was called to investigate a minor crash involving a young woman who had hit a parked car. According to investigators, he was expected to conduct a standard DWI assessment, but the encounter took an unexpected turn. A warrant later alleged that instead of completing the required procedure, Cogdill used his position to offer leniency in exchange for inappropriate favors. Authorities say he then drove the woman to his apartment while still on duty, and returned her the next morning without filing any official report. The incident left the woman deeply distressed and eventually led her to come forward through an attorney.
A young woman taken advantage of, somebody who's a predator with a badge. There's not much more scary than that. It's been very devastating for her. She's been very traumatized through this whole process, but we do commend her. She's a strong young woman, and we believe she's stopped a predator. She looks forward to looking her accuser in the eyes in the courtroom.
As the investigation unfolded, Raleigh police terminated Cogdell, and he was arrested shortly after. In court, he faced several felony charges, including obstruction of justice, misconduct involving a person in custody, and willful neglect of duty. Prosecutors revealed that more individuals have since contacted investigators with similar concerns, and those claims are now being reviewed. During his brief court appearance, Cogdell did not address the media, while the woman's attorney stated she hopes speaking up will help protect others. If convicted, Cogdell could face significant prison time as the case continues through the legal system. In early October, emergency crews in Tulare County were called to a home in Porterville where they found Sheena Hoffman with severe burn-in. She was quickly transferred to a specialized hospital in Bakersfield and placed in a medically induced coma due to the extent of her condition. Investigators from the Tulare County Sheriff's Office later arrested her husband, Sean Hoffman, in connection with the incident. Court records show he was already out on bail for a 2024 burglary case at the time. On October 14th, Sean appeared in court for his arraignment, where he entered a not guilty plea to charges including attempted murder and torture. Outside the courthouse, dozens of family members, friends gathered with signs supporting Sheena and calling for justice.
And it's just been a lot, mentally, physically, emotionally. Sheena's my friend. She's been my friend for years. Sean's my friend. He's been my friend for years. And I'm just in disbelief about this whole thing happening.
I just hope the whole truth comes out and that hopefully my dad did it, but I'm not going to say he didn't do it because none of us really know. So I just hope the truth comes out and everyone's okay.
If it shows that he did this, I hope justice is served. But Sheena's a victim, the kids are a victim, everybody's a victim in this. Sheena's gonna be scarred for the rest of her life. Every day she looks in the mirror, she's gonna see those scars. And she's gonna carry that with her. There's no getting over this.
Loved ones described the situation as heartbreaking and confusing, saying they simply want the truth to come out as the investigation continues. Sean is scheduled to return to court on October 23rd, while Sheena remains in critical condition, facing a long and difficult recovery. In July 2022, North Kansas City police officer Daniel Vasquez pulled over a driver, Joshua Rocha, for expired temporary tags. What should have been a routine stop turned tragic when Rocha reacted in a way that cost the officer his life and sent shockwaves through the community. Rocha fled afterward but later surrendered, beginning a long legal process marked by grief, investigation, and preparation for a capital murder trial. Over time, prosecutors announced they would seek the death penalty, while Rocha's defense highlighted his troubled background and mental health struggles. After a week-long trial, a jury found Rocha guilty of first-degree murder. The case then moved to the sentencing phase, where jurors listened to emotional testimony from law enforcement and Officer Vasquez's family. In October 2025, they recommended the death penalty, calling Rocha fully responsible for the loss.
We got justice for Daniel today. Today's verdict makes clear he will not escape justice. I pray only that seeing justice done brings a small measure of peace to Daniel's family and our community.
The courtroom was filled with quiet tears and relief as the verdict was read, marking the department's first line-of-duty death and a profound moment for the community.
Nothing can bring back Danny, but we are happy that justice was served today. We can only hope to use this as a time to move forward and continue to serve with courage amongst the citizens of North Kansas City like he did.
Rocha will be formally sentenced in November, and although his defense has the right to appeal, prosecutors say the verdict delivers a long-awaited measure of justice for Officer Vasquez's loved ones. In 2022, a normal workday at a Fresno car dealership was shattered when Manuel Bracker suddenly entered the Lithia Ford showroom and carried out an unprovoked attack on an employee. Investigators later learned he had picked up a weapon from a nearby store before walking into the dealership. The employee survived but was left with long-term physical and emotional injuries. Police recovered the weapon near a highway and quickly identified Bracker as the suspect. Court records also showed he had a previous violent conviction from 2019. Over nearly 3 years, Bracker repeatedly denied responsibility while the case moved through the courts.
Clear, I believe it's not in dispute. The mental health status of Mr. Bracker has always been at play, whether it be on the prior or in this particular case.
In August 2025, he finally entered a guilty plea to attempted murder and assault, and a psychological evaluation confirmed he was legally sane at the time of the incident. During sentencing, the victim described how the attack changed his life.
Is senseless and how the attack has dramatically affected me mentally and physically, and the ongoing physical and emotional pain I am left with is a daily reminder of his attempt to take my life. I do not ultimately wish to defend any ill will, but we all need to take responsibility and ownership for our actions.
Prosecutors argued that Breaker's actions showed clear intent.
The conduct is not only dangerous to public safety, but it was a life-changing event for each of the victims who were subject to any interaction with Mr. Bracker whatsoever.
Mr. Bracker's conduct during and after the incident.
The judge ultimately sentenced him to 14 years to life, plus an additional 3 years in state prison. With credit for time served, Bracker will now begin serving the remainder of his sentence and has 60 days to file an appeal. In 1996, Lake Oswego resident Susie Larson was preparing for her upcoming wedding when she met with Billy Lee Oatney, a man she knew who had offered to make her a pair of earrings for the ceremony. She never returned home from that meeting. After a 2-week search, authorities found her body in a rural area near Champoeg State Park. Investigators soon identified Oatney as a suspect, and in 1998, a jury convicted him of her murder and sentenced him to death. Nearly 2 decades later, in 2015, the Oregon Court of Appeals overturned Oatney's conviction, ruling that his original defense attorney had failed to provide adequate representation. This decision set the stage for a full retrial. In early 2023, prosecutors presented the case again, and a new jury found Oatney guilty for a second time. At sentencing, the judge concluded that Oatney posed a continuing danger and would not be rehabilitated.
He looks at the world as potential prey. He's a dangerous individual that never should see the light of day outside the walls of a prison.
This man here is in perfectly good shape to go and do it again, and he probably wants to. He has sat there and shown not one ounce of remorse or care about Susie or any of us.
He was sentenced to life in prison without the possibility of parole, a result Susie Larson's family had long hoped for, bringing some measure of resolution to a case that had stretched across nearly 3 decades. The case of Larissa Rodriguez began unfolding in December 2017 when Cleveland police received an unexpected call from a U.S. service member stationed overseas. He told officers that his brother had confessed something deeply unsettling. Larissa's son, Jordan, was no longer alive. That report prompted police to conduct a welfare check at the Rodriguez home. When officers arrived, Larissa claimed Jordan was staying with relatives in Texas. Detectives quickly realized that her explanation didn't align with school records, medical appointments, or earlier case files. Jordan had missed numerous mandatory check-ins, and agencies had already documented concerns about the family's living conditions. As investigators pressed Larissa further, her story shifted, raising even more suspicion. Detectives obtained a search warrant and began examining the property. In the backyard, they uncovered the remains of Jordan. The discovery confirmed that he had died months earlier and that his disappearance had been deliberately concealed. The medical examiner could not establish an exact cause of death due to the condition of the remains, but the findings pointed towards severe neglect. The prosecution later revealed that Jordan had special needs, required regular care, and was extremely vulnerable. Despite that, Larissa had continued collecting benefits for him and repeatedly told caseworkers that he was living with his father out of state, a story investigators proved false. As detectives pieced together what happened, they found evidence of prolonged neglect inside the home. Reports described unhealthy living conditions, missed medical visits, and a pattern of avoiding welfare checks. Witnesses told investigators that Jordan often appeared underweight and in need of help. Authorities also uncovered that Larissa and her boyfriend, Christopher Rodriguez, took conscious steps to hide the truth. Instead of seeking medical assistance or reporting the boy's death, they buried him and attempted to move on with their lives. Their actions, prosecutors said, showed a deliberate effort to avoid responsibility and mislead both authorities and family members. With the evidence mounting, Larissa and Christopher were arrested and charged with involuntary manslaughter, felonious assault, children, and abuse of a corpse. Faced with overwhelming proof, including their own conflicting statements, welfare agency records, and the discovery in the backyard, both defendants pleaded guilty in June. 2018 prosecutors argued that the case represented a tragic chain of neglect rather than a sudden emergency. Jordan had been missing from essential care for months, unnoticed by those responsible for him, and the truth only came to light because someone far away decided to speak up.
Is a family friend, Maria Cruz.
they have prepared a statement. On behalf of Jordan's extended family, we want the court to know that we not only loved him, but we attempted to intervene on his behalf of all the children. Those attempts were rebuffed by both Larissa and Christopher. We specifically recall one opportunity that we had to keep Jordan overnight in our home. Jordan, although nonverbal, was able to communicate with us and shared a special family meal seated on his Uncle Jose's lap. Our point in sharing this story, Judge, is to illustrate that Jordan thrived with love and affection. He was delayed in his cognitive development, but he clearly showed his love by running to his Uncle Jose when he came home from work. Jordan was a special, sweet little boy who would have developed and bloomed into a special soul. It is our deepest sadness to have this sweet boy's life extinguished and buried in an unmarked grave. As a family, we love Larissa because she too is our family. However, we can never reconcile ourselves with her deeds. We hope that you take our thoughts into consideration when you hold Jordan's parent accountable today, the Rodriguez and Cruz families. Your Honor, on behalf of the state of Ohio, Jordan Rodriguez was born on November 5th, 2012. He was born 26 weeks premature and had a whole host of medical issues. He was born with one functioning kidneys and other heart and breathing issues. He was enrolled at Cleveland Metropolitan School District, where they actually tried to help with an IEP and help with his developmental delays because he was, of course, nonverbal. Jordan was withdrawn by his mother on September 13, 2016, and told officials at the school that he was moving out of state. Jordan's last medical care ceased on or about November of 2015. Per Larissa, when she was questioned about her child, she said he was out of town, and she repeatedly said that. Then finally, when she was confronted with the fact that that child may have been buried in her backyard, she told Detective Remington, this is what happened on September 21st. While getting the kids ready for school, Christopher brought Jordan in to the bathroom where he was in a semi-conscious state. She tried to revive him with a cold shower, and then she laid him in bed for 24 hours. And she makes it a point to tell Detective Remington that she laid him in bed, in her bed, because she wanted to be close to him. She woke up the next morning of September 22nd, and he was dead. Larissa and the co-defendant Christopher decide to dig a hole which is 4 foot by 4 foot. They wrap him in numerous blankets, garbage bags, duffel bag, and bury him in the backyard. And you will find, Judge, I have provided to this court under seal State's Exhibit A1, 1A to 1H, which are several photographs of the time and energy that it took to this child. And the very last photograph is a picture of Jordan when he came out of the bag. He had a diaper on him, he had a pajama top, and some shorts. And the reason for showing you these photographs, Judge, is to show you the time and the energy that it took to bury this child versus dialing 911 for help. And the state is also going to give you State's Exhibit number 2, which is an autopsy. So as she continues to talk to Detective Remington, she claims that that she herself has suffered abuse at the hands of Christopher Rodriguez, and that abuse transferred to her kids. But she would never go any further than that to articulate anything else. So if it wasn't for Scott Rodriguez calling the police on December 19th, 2017 from Pakistan and telling Cleveland Police Department that a child was buried in the backyard of her home, this child may still have been there, Your Honor. So I'm going to hand you the State's Exhibit 1A through H and 2, and I'm also going to make note of the fact that you will find in the autopsy that there were healing fractures and acute fractures. The healing fractures, Your Honor, were of the ribs, and specifically there was a wrist fracture, and then there were healing ribs 6, 8, 10 on the right side and 8 on the left side. Those are most consistent with child abuse according to our medical examiner.
At sentencing, the judge acknowledged the extensive investigative work and the tragic nature of the case, but remained brief in personal expression. What mattered most, she said, was accountability.
First, I want to say that the serviceman who made this phone call, it's so important that he did that, and I don't want him to go unrecognized, because I can't imagine the trauma that he had hearing this in a foreign country, that his brother had done something like this, asking his brother to take accountability. And then because his brother doesn't want to be a man, he has to do it, but he did it, and I give him credit for doing that. The other thing that this case, I think, really drives home is that there's insufficient consideration given to the people that work in the criminal justice system. So I want to say to the police, to the detectives Remington and Diaz, I certainly know that your job is very difficult. And I look at these photographs, and it's very hard. And I think you should be recognized more for the difficulty of what you do. And the same to the state and to the defense. This is equally difficult for you. What we do every day is so hard. People don't give any of us the credit that we deserve for dealing with the horrors that are brought before us. And Mr. Rodriguez, this is a horror. I know as a judge I'm not supposed to show emotion. And in 22 years, I never have. This is one of the worst things I've ever seen in my life. And I don't understand, Mr. Rodriguez, why you don't want to cleanse yourself and tell the truth about what happened here. And I hope someday you do. Whatever this child's life was supposed to be, you made sure it didn't happen. You and Larissa. I look at friends and family and people who are desperate to have children and want to have families, and you two have babies with no consideration. You just keep having them, disregarding the value of their life, disregarding their purpose in life, like they're less than an object. No regard. I didn't even hear you say you were sorry. I will not accept the recommendation for Mr. Rodriguez. These crimes are horrific. There's no question in my mind that this child was abused. It's clear that you did everything you could, you and Larissa, to hide evidence to protect yourselves. You had every opportunity at so many points to make a difference, to get help, to stop beating somebody, to call the police, to ask for help, to try to take him to the hospital. I have to imagine that at some point you got on the internet and said, how do I bury a body? Because this is unbelievable. to me. The level of meticulousness that you went through to not be discovered. I honestly don't know how you live with yourself. I don't know how either one of you live with yourself. The court imposed a sentence as follows. Count 1, involuntary manslaughter, felony of the first degree, 11 years in prison. Count 2, felony of the second degree, felonious assault, 8 years in prison. Count 3, felony of the second degree, 6 years in prison. Count 5, abuse of a corpse, felony of the fifth degree, 9 months in prison. Counts 1, 2, and 3 to be served consecutive to each other and concurrent to the sentence imposed in count 5 for a total sentence of 25 years. The sentence is to be served concurrent to the sentence previously imposed in 625-508 for a total sentence of 25 years. Your sentence as follows. Count 1, involuntary manslaughter, 11 years in prison. Count 2, felony of the second degree, felonious assault, 8 years in prison. Count 3, felony of the second degree, 8 years in prison. Count 5, abuse of a corpse, 1 year in prison, all counts to be served consecutive to each other with credit for any time served. That's a total sentence of 28 years. That's the maximum sentence available.
Larissa was sentenced to 25 years in prison, and Christopher received 28 years. Both sentences reflected the seriousness of the charges and the long period during which Jordan's well-being had been ignored. Michael Crane's long criminal history in Arizona began years before the case that made headlines. In 2009, he had already been convicted of felony drug-related offenses and promoting contraband, establishing a record that would later elevate the penalties for any future crimes. Over the next several years, detectives linked him to a series of burglaries in Phoenix, where several homes were entered without permission and valuable items disappeared. Investigators recovered stolen property and traced evidence back to Crane, eventually connecting him to multiple break-ins from both 2009 and 2011. By early 2012, Crane's behavior escalated. In January of that year, police were called to 2 separate homes, first in Phoenix, then 4 days later in Paradise Valley, after both residences were found damaged and burned. In each case, items had been taken and the homes set on fire. Once the scenes were processed, investigators discovered that 3 people had been killed in connection with these crimes: Bruce Godet in Phoenix and Dr. Lawrence Shapiro and his wife, Glenna, in Paradise Valley. Detectives collected a combination of physical evidence, stolen belongings, witness statements, and DNA that pointed toward Crane as the central figure behind the spree. He was arrested soon after. While awaiting trial on the murder charges, prosecutors also moved forward with the earlier burglary and weapons cases. Eventually, faced with overwhelming evidence, Crane agreed to plead guilty. In the 2012 case, he pleaded guilty to the 3 killings, the burglaries tied to those incidents, and the arson that followed at both homes. In exchange, prosecutors removed the death penalty option.
It's my understanding that you wish to change your plea in the 7950 case to count 1 burglary with 2 prior felonies, class 3 non-dangerous repetitive offense committed November 30th, 2011, between November 30th, 2011 and December 5th, 2011. Count 2 theft with 2 prior felonies, a class 4 non-dangerous repetitive offense committed December 6, 2011. Count 3, misconduct on weapons with 2 prior felonies, a class 4 non-dangerous repetitive offense committed December 6, 2011. Is that correct?
Correct.
You understand that if you plead guilty, you subject yourself to a mandatory prison sentence for each of those 3 counts. Do you understand that, sir?
No.
It's a repetitive offense. The law would mandate that you get a prison term that's presumed to be 11 1/4 years on the burglary count, 10 years on the theft and the weapons charge. Under the law, it could go up to 25 years in the burglary case, 15 years on the theft and the weapons charge.
I understand what you're saying, but I don't understand how this works. But go on.
Well, I need to make sure that you know what you're doing and you understand what you're doing and you want to do what you're doing. But what questions do you have so far?
What difference does it matter if I plead guilty, if I say I take the responsibility for all these charges and you guys have a trial? What difference does it make if I do this now or later?
Well, I don't know what later is. Today relates to 2 cases.
Do you understand what I'm saying to you, though?
Well, I don't. You know better than I do what later means.
I really don't.
Well, no one can force you to change your plea, Mr. Crane. Right now, the options are going to be a plea or a trial in 3 cases.
I've already told you that I'm willing to accept responsibility for all these charges. So that is what I'm telling you right now.
Well, and I'm answering in that, in order for me to accept that choice by you, I have to make sure that you understand the ramifications of that choice. And among the ramifications is
I understand the ramifications that you're telling me, but I don't agree with them.
Well,
that's one of the, I'm here on special visitation only. You need to remember that.
Well,
Rights are reserved under UCC 1-308. You need to remember that.
And we've talked about that too, but I have to take baby steps to go through this, Mr. Crane, and if you can't follow me, then we won't do it.
Here, may I have just one moment?
Yes?
I don't think you understand either. Excuse me? Trial or not, there's nothing. It doesn't matter. We're going to go to trial. We're going to sit here. We're going to say nothing at all. I don't even want you guys representing me in the first place. You know that. My position stands firm on this. There's nothing to say, period. Let's go ahead and go through these proceedings, but just understand that one way or another, this is you're forcing me in the contract by keeping me in a jail cell, by keeping me confined. We'll go. Like I told you, I'm accepting responsibility for these charges. I don't agree with your commercial ruling fraud that you commit every day in this court. I don't know what else to do. I don't know what to do.
Well, you and I are going to engage in a conversation, and we'll see where we are at the end of it.
Let's go with that.
All right. You understand that by pleading guilty, you are going to be facing mandatory prison for each of these 3 counts.
I understand that's what you're telling me.
The presumed sentence for the burglary charge is 11.25 years. It could legally go down to 7.5 years. It could legally go up to 25 years. Do you understand that?
I understand that.
With respect to the theft and the weapons charge, the presumed sentence is 10 years. It legally go down to 6 years, and it could legally up to 15 years. Do you understand that?
I understand, but I don't agree with that.
It would be lawful to run these concurrent with each other. It would be lawful to run these stacked on top of each other. Do you understand that?
I understand that, but I don't agree with that.
Each one of these would be an 85% count. Do you understand that?
I understand that, but I don't agree with that.
In the 999 case, it's my understanding that you are intending to plead guilty to count 1 burglary with 2 prior felonies, a class 3 non-dangerous repetitive offense committed between January 31, 2009 and February 12, 2009. Count 2 burglary with 2 prior felonies, a class 3 non-dangerous repetitive offense committed between May 28, 2009 and June 3, 2009. Is that your understanding?
I understand it, but I don't agree with it.
Well, are you willing to do it?
What do you mean?
The fact that you don't agree could mean that
I don't agree with the laws I'm being charged. I've told you, I've already told you this already. I'll say it again. I accept the responsibility for the crimes that I'm being charged with.
By accepting responsibility, that means that you would be facing mandatory prison for both of these counts as well. Do you understand?
I understand that, but I don't agree with that.
The presumed term is 11.25 years. It could legally go down to 7.5 years. It could legally up to 25 years. Do you understand that?
I understand that, but I don't agree with that.
If you are sentenced, the sentences could run concurrent with each other, or they could be stacked on top of each other. Do you understand that?
I understand that, but I don't agree with that.
The sentences in this case could run concurrent with or be stacked on top of the other case. Do you understand that?
I do, but I don't agree with it.
You understand that if you plead guilty, you're giving up constitutional rights.
Which constitution are we talking about?
The right to remain silent.
Which constitution are we talking about?
The U.S. Constitution.
Which U.S. are we talking? Are we talking about the federal Constitution of the District of Columbia, that U.S. Constitution, or are we talking about the States of the Union common law Constitution? Which Constitution are we talking about?
You'd be giving up your Fifth Amendment right.
I'm asking a question. You're not answering my question. You're committing fraud by remaining silent on this issue. My question is real simple. You're asking me questions. I'm asking you questions. I'm not trying to be difficult. I want to get this over with. I've been here for almost 7 years. I'm asking you a simple question. Are we working under the common law, or are we using a federal constitution?
The federal constitution. And Mr. Crane, if you don't want to engage in the rules, then that's fine. We can proceed.
I don't agree with the rules. I don't have a choice either way. You are giving me no choice. You're forcing me to have counseling. You're forcing me to go to trial. I have no choice in any of these matters whatsoever. The only thing that I can do is protect myself the best that I can. Most of this stuff, I just have a basic comprehension of. So I ask you again, are we working under admiralty law, under statutory jurisdiction?
No.
We're not. Really? Okay. That's going in a lawsuit right there. You just committed fraud. Thank you very much again.
You're giving up your right to remain silent, your privilege against self-incrimination, your right to refuse to testify, your right to plead not guilty. Do you understand that, sir?
I understand that, but that's not under the original Constitution, the original Bill of Rights.
You're giving up your right to a jury trial where you'd be represented by a lawyer. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to cross-examine or question any witness the state called. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to call witnesses, present evidence, and testify yourself if you wanted to. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to have the jury determine your guilt beyond a reasonable doubt. Do you understand that?
Excellent. I said excellent, but I don't agree with that.
You're giving up your right to have that jury determine any aggravating factors beyond a reasonable doubt. Do you understand that?
I understand it, but I don't agree with it.
You're giving up your right to file a direct appeal of your case. Instead, the way you appeal is to me. If I turn you down your claim, you can go to the appeals court, but they won't have to take your case. Do you understand all of that?
They don't have to take my case anyway. They're just as corrupt as you.
Knowing that you're giving up all of these rights by entering into these plea agreements, this change of plea, is that what you want to do?
I don't have much of a choice here.
Yeah, you have an absolute choice.
I really don't. I really, really don't.
Your choice is to go to trial, or your choice is to plead. That's up to you.
One way or the other, I'm telling you, I did everything that you're telling me I did. It's going to happen in trial here, so yes, I agree.
Have you had enough time to think about this?
I'd say plenty of it.
Has anybody forced you to make this decision?
Absolutely.
What has forced you to make this decision?
Let's see, 7 years in confinement in 4th Avenue Jail. You guys not answering my questions. You're giving me no choice. You're forcing me to have counsel. You're not allowing me to represent myself in a pro per status or a proper sui juris status by you not answering my questions, by the state not answering my questions.
Has anybody threatened you to make this decision?
Absolutely.
How so?
Every single time that I'm either forced to come to this courtroom, which I am here under duress and under threat with my life, or further imprisonment in the 4th Avenue Jail, absolutely. What do you mean? What kind of question is that? Serious?
Are you asking that I accept your plea?
Absolutely. What are you asking me? What are you saying to me right now? I don't understand what you're saying.
You want me to accept your plea of guilty?
Do you want to accept my plea?
I'm not at issue here, Mr. Crane. The only issue today is whether you are entering a change of plea that's knowing, intelligent, and voluntary, and whether this is something that you know what you're doing and you want to do it.
One way or the other. Let's be straight up here. Like I said, I'm not an attorney. These guys won't answer my questions. You won't answer my questions. The state won't answer my questions. So let's just say this. I will say yes under the presumption that my right, that you understand and know that I am here under duress. I am here under special visitation. I'm not accepting your laws one way or the other. Okay, and that I'm reserving my right to the Uniform Commercial Code UCC 1-308 and UCC 1-103.
Is it okay that I accept your changes of plea, Mr. Crane?
Under the terms and conditions that I just stated, only, without prejudice.
Is it true in between November 30th, 2011 and December 5th, 2011, You went on the premises of someone lived on Broomfield without their permission.
Correct.
And you took property that was not yours to take.
Correct.
And you were armed at the time.
Correct.
And among the things that you took was a motorcycle.
Correct.
And you would agree that the value of that motorcycle was between $3,000 and $4,000.
Yes, correct.
And that you took a rifle.
A rifle?
Yes.
When that happened? Yes, so yeah, let's say it. Why not?
A J.C. Higgins rifle? He just had it?
Correct, I guess. Go ahead. It doesn't matter at this point. Go ahead, correct.
I can't let you plead if there's not a crime, Mr. Crane.
Your Honor, regarding the factual basis on the misconduct involving weapons, that was actually at another location, his grandmother's house, where there was a J.C. Higgins that was found. That's separate and at a different location from the Bloomfield address.
Let's make it not separate. Just go ahead and add it to the.
Well, is it true, Mr. Crane, on December 6th you had possession of a rifle?
Sure, why not?
And I know prior pleadings that you have filed, you think it's unconstitutional, but you would concede that you did not have your rights restored when you had the rifle.
I've never had my rights taken away. If you look at any of those contracts I signed, my rights were reserved to Uniform Commercial Code 1-207 at the time and 1-103. I never gave up my rights.
I understand that, but you never got them restored either.
They were never taken away. It was an unclosed deal. It was an unclosed matter. Can't take away my rights, period, anyways. My rights are inalienable, sir. Now, if we're talking about the federal constitution and we're talking about the District of Columbia, certainly you could take away my rights. If you're calling me a person or a domicile or an agent that is a domicile in the District of Columbia, sure, you can take away my rights, but I am neither of those. I'm an American man born in the States of the Union.
Let me change the subject to get back to that weapons charge then. Is it true that back in 2010 you were convicted of the felony offense of possession of drug paraphernalia?
Yes.
And you had a lawyer that represented you in that case?
I did.
And in 2010 you were convicted of the crime, the felony of facilitation to promote prison contraband?
Correct.
You had a lawyer that represented you in that case?
Correct.
And then by
much younger and stupider version than me.
By reason of those convictions, you had lost your constitutional right.
I never gave them up.
Well, let me take these baby steps I told you, Mr.
Okay.
Crane. You had lost your right to possess a weapon. Had you gotten permission to get a weapon from DPS?
That's what the District of Columbia, that's what the sub-franchisee, Arizona, is saying. But you can't take away rights that are inalienable. I never signed them away. At the time that I did that, I reserved my rights to the Uniform Commercial Code, which reserves my rights to the common law. And in accordance with the common law, you can never take away my rights, period, ever. Check the files if you don't believe me. Go right on ahead. Every single document from that stage, from the signing process, reserve my rights to the common law.
That was one of the issues you raised earlier. I ruled earlier.
I don't even remember raising that issue earlier.
It is subject to review, I guess. So the question I have for you is, did you get your rights restored by DPS after your felony conviction?
Rights restored, that's what I'm telling you.
I'm sorry?
I never had to get my rights restored is what I'm telling you.
I understand what you're saying, but did you?
I'm telling you that I never had my rights taken away from me in the first place.
Okay. In the 999 case, is it
say whatever you want to say? That's just some bullshit.
In the 999 case, is it true that between January 31, 2009 and February 12, 2009, you went into a residence on Lafayette Boulevard without permission?
Correct.
For the purpose of taking stuff that was not yours?
Correct.
And you were armed at the time?
Correct.
Is it true that in that
was I armed?
Between May 28th, 2009 and June 3rd, 2009, you went to a residence on 35th Place?
Correct.
Without permission?
Correct.
and took property that was not yours to take.
Absolutely.
You were armed at the time.
Absolutely.
And in those instances, there was someone there with you.
No.
There was someone that got you there or helped get rid of the property.
No.
Ms. Stevens, is there a basis for the accomplice charge on either count 1 or count 2 in the 999 case?
Your Honor, in regard to the 999 case, the laboratory results show that a Brittany Beinhauer was present at the scene of the burglaries charged under that cause number.
For both of the places?
On one of them, Judge, if I may.
That would be count 2.
That's the, so someone else was with you at the 35th Avenue, 35th Place residence, Mr.
What? Give me the address. I can't.
35th Place. I don't know if you know the gentleman's name.
I can't even remember what. I don't know what you're talking about. What's the place called? What's the address?
35th Place.
And what?
I don't know the answer to that, and I'll get it for you.
No.
Yeah, that was in Phoenix, Your Honor, Maricopa County.
Say again?
That was in Phoenix, Maricopa County.
Right.
Say was or wasn't?
Was.
Was.
No. No, I have no idea what what we're talking about right now. I think I'm being honest. You're dishonorable, Brandon. You could believe that. I'm going to say no regardless. I'm not a fucking rat.
Okay.
But no, honestly, I've never done anything with that woman.
Mr. Crane, is it true that in February of 2017,
never even seen that place before. Nice house. Is that right?
Mr. Crane?
Yeah.
Is it true that in February of 2017 you entered into a change of plea to count 4 aggravated assault, a class 3, dangerous with 2 prior felony, committed February 1st, 2012?
Yeah.
Count 5 armed robbery, a class 2 dangerous with 2 prior felonies, committed February 1, 2012. Is that true?
Correct.
Count 6 burglary, a class 2 dangerous felony with 2 prior felonies, committed February 1, 2012.
Correct.
Count 7 armed robbery, a class 2 dangerous with 2 prior felonies, committed February 1, 2012.
Correct.
Count 8 aggravated assault, a class 3 dangerous felony with 2 prior felonies, committed February 1, 2012. Count 9 attempted burglary with 2 prior felonies, a class 4 non-dangerous repetitive offense, committed February 1, 2012.
Correct.
I had found that those pleas were knowingly, intelligently, and voluntarily made and accepted the pleas. Is that also true?
No. Not in the way I reserve my rights to the uniform.
You did?
They were made without prejudice.
The same way today,
in accordance with UCC 1-308.
You are going to seek to vacate everything that we've done. I understand that.
What do you mean?
You're going to appeal everything that we're doing.
I'm not going to appeal.
Well, then
I don't even want to appeal.
Well, then
there's nothing to appeal.
I go back to the fact that you're going to be sentenced to prison on all of these counts. Then
that's what you're telling me.
I
don't agree with it, but that's what you're telling me.
Have you had?
I'm giving you permission to send me to prison. I'm not going to sign a contract that's going to send me to prison, not voluntarily.
Have you had
But
any-
you have told me this. You said that you have the power to force me into signing a contract. I remember that. Do you remember saying that?
Have you had any?
Do you remember saying that?
I remember telling you how to sign anything.
Do you remember when I asked you, if we go to trial and I lose trial, and I asked you this question specifically, my memory's working right now, that's awesome. And I asked you this question specifically. I said, do you or the state have the power to force me to sign a contract that's going to send me to prison? And you said yes. Am I correct about that?
He's talking, Your Honor, about at the end of either a plea where he signs his rights, whether it's through a trial or through
He knows
a
what I'm
plea.
talking about.
And
Well, your phrasing of a contract is, I don't accept that premise, but
Oh, excuse me. What does that mean? You say you don't accept that premise. You said those words to me personally. Did you not?
I would not.
Let me ask you the question again. Let me ask you this question again. If I go to trial right now and I lose and I'm found guilty of every single one of these charges, okay? Do you have the power? Are you saying that you have the authority to force me, an American man, not born in the States of the Union, force me into a contract, sign a contract that's going to send me to prison? Because this is what this comes down to at the end of the day.
It would not be a contract.
What are you speaking of?
I would order that you be remanded to custody of the Department of Corrections.
At the end of these proceedings, one way or the other, there's a contract that I sign that sends me to prison. You said that you had the power to force me to sign a contract. Are you going back on what you said?
You keep using the term contract. There's paperwork at the end to
Paperwork's contract. This is what, I mean, are we serious? Are we
get
being
a
serious
fingerprint
right
to make sure that we got the right
now?
guy.
Okay, so you have the power to force me to put my fingerprint on a document that you're saying is not a contract, not a commercial contract that involves color money and color law? Is that what you're telling me right now?
Yes.
Wow. Okay. Thank you. That's all I wanted to hear.
Have you had any drugs, alcohol, or medicine in the last 24 hours?
Absolutely not.
Has the jail prescribed you medicine that you've chosen not to take?
Absolutely.
When's the last time you had any medicine?
I can't remember.
The fact that you have not had prescribed medicine, do you think that affects your ability to understand what we're doing?
I doubt it.
Again, I'll ask Mr. Crane, are you asking that I accept your pleas today?
Only under my terms and conditions.
Which are?
That you accept and without prejudice in harmony with UCC 1-308 and UCC 1-103.
Okay.
Okay.
I understand what you're saying. I have to accept your plea under the Arizona Constitution, the U.S. Constitution, and Arizona statutes.
Which uses Uniform Commercial Code law.
Title 13.
Business transactions.
Title 13. Either counsel have any questions on the sufficiency of the factual basis for counts 1, 2, or 3 in the 950 case, counts 1 and 2 in the 999 case?
Judge, I don't have any question about the sufficiency of the factual basis. I think we have in this hearing and previous hearings covered the legal issue this defendant has with jurisdiction. I just wanted to add, because I'm not sure we covered it, that all of the counts that you mentioned were in the city of Phoenix and Maricopa. The state is in compliance with victims' rights, although this isn't a plea agreement, it's a plea straight to the court.
Mr. Crane, all of these locations you would concede were in Maricopa County?
Correct.
Counsel, anything on the sufficiency of the factual basis for any of the counts today?
Yes, Your Honor. I just wanted to, I believe, correct the record as to count 1 on the that is in the 7950 number. Even though Mr. Crane admitted that he was armed at the time, there was nothing to indicate in the discovery that we reviewed to indicate that he was armed at that time as to count 1. Also, I just want to clarify that as to count 2 regarding the motorcycle that was actually found at a different location although it belonged to the owner of the resident on Bloomfield. And finally, the J.C. Higgins rifle was again at a different location. And finally, as to the two in the 09999 clause number that was in Maricopa County, that was at a basically at a condominium type location, and the way Mr. Crane was connected to that location was they found his DNA on some bottles, and also the other co-defendant at that location. And again, that was within Maricopa County.
Thank you. Any counsel have any questions on the knowing, intelligent, or voluntary nature of Mr. Crane's plea to any of the charges?
I have nothing to add, Judge.
I'm sorry?
I have nothing to add.
Your Honor, yes, we would object. We do not believe that Mr. Crane's plea is knowingly, intelligently, or voluntarily made based on his responses today in court, based on my hour-and-a-half meeting with him.
Throughout the plea process, Crane often challenged the court's authority, raising arguments about constitutional interpretations and jurisdiction. Despite his objections, he repeatedly acknowledged committing the acts themselves. At sentencing, the judge reviewed the severity of the crimes and the lengthy history behind them. Crane was ordered to serve 3 consecutive life sentences, ensuring he would never be released from prison. Crane would remain behind bars for the rest of his life. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.